Goodness. Guys, I'm going to have to leave and come back in because I'm having an issue with my screen, if that's all right.
Okay, sure.
Okay.
No problem.
طيب شباب اخباركم ايه؟ سامعيني كويس؟ طيب انتوا مش عارفوا دلوقتي تكتبوا اي حاجه خالص او يكون عندكم اي طريقه للكلام، فاي حاجه عايزين تقولوها عايزين تتكلموا فيها عندكم تحت حاجه اسمها Q&A، دوسوا عليها تعرفوا فيها كل التفاصيل. عشان تسمعوني كويس لازم تشغلوا حاجه اسمها الترجمه، تسمعوا من انجلش لعربي. عندكم تحت علامه كوره بتاع الترجمه. الحين هفتح لكم الشات عشان لو في حاجه تبعتوها عليه
بالظبط.
لحد ما نقدر نظبط الدنيا. اول حاجه سامعيني كويس؟ شباب سامعيني كويس؟
ممكن تكتبوا في الشات يا جماعه لو سامعين كويس.
تمام جدا. طيب في على الجنب تحت علامه كوره شايفينها؟ طيب بندوس عليها بيظهر لنا اختيارين انجلش وعربي. لو عايزين نسمع بالانجلش هندوس على الانجلش، لو نسمع بالعربي هندوس على العربي. هي حاليا الانجلش هتكون شغاله، لو انت هتسمع بالانجليزي هتختار اوف، هتسمع بالعربي هتختار بالعربي. تمام؟
اوكي.
طيب خلي اللغه بالعربي. تمام. طيب احنا هنبدا حالا. we are ready.
Okay.
Hello.
Hello. I think we have Clara with us. Yes, perfect. Hello, everyone. Thank you so much for joining us today, and I hope everyone is doing great. First of all, I would like to welcome you and welcome Clara with us. Today's session is going to be very, very interesting. And as I mentioned in my message to you in the WhatsApp group, it's going to be about intellectual property rights. And today's session wouldn't have been possible without our partners, Hatch Ideas UK. So I would really like to thank them. And we actually prepared a couple of videos for you, but I don't think we have the time, but I can go through that. I have 2 more videos, but I don't think we have the time, so I'm gonna skip through the slides. And I want to show you a small infographic video. It's about intellectual property rights. And I think it's gonna be very, as a brief for today's session. So
بتعرف الملكية الفكرية بأنها إبداعات العقل من اختراعات ومصنفات أدبية وفنية بيتم استخدامها في التجارة، وده وفقاً للمنظمة العالمية للملكية الفكرية ويبو. الملكية الفكرية ليها أنواع مختلفة محمية قانونياً بحقوق وعقوبات ومدة زمنية معينة لكل نوع، زي العلامات التجارية وبراءات الاختراع وحقوق النشر والتصاميم الصناعية والمؤشرات الجغرافية والأسرار التجارية. مصر تعتبر من أوائل الدول اللي اهتمت بحماية حقوق الملكية الفكرية وانضمت للعديد من المعاهدات الدولية. وفقاً لتقرير التنافسية العالمية لسنة 2019 الصادر عن المنتدى الاقتصادي العالمي، مصر احتلت المركز 89 من 141 بالنسبة لمؤشر حماية حقوق الملكية الفكرية، مقارنة بالمركز 124 لسنة 2018. من الغلطات اللي كتير من رواد الأعمال بيقعوا فيها هي قلة الاهتمام بتسجيل الملكية الفكرية لشركتهم الناشئة، وده بيرجع لقلة الوعي بأهمية حقوق الملكية الفكرية والوقت والفلوس اللي بيضيعوا في عملية التسجيل، وتعدد الجهات الحكومية اللي بتقوم بتسجيل الملكية الفكرية زي أكاديمية البحث العلمي، جهاز تنمية التجارة الداخلية، المجلس الأعلى للثقافة، هيئة تنمية صناعة تكنولوجيا المعلومات. تسجيل الملكية الفكرية مش بس بيحمي رواد الأعمال من إن أفكارهم تتسرق، وكمان بيديهم ثقة ومصداقية أكبر لما يتعاملوا مع مستثمرين أو شركاء محتملين.
I hope you found this video helpful. And as I mentioned, today's session is about how to protect your intellectual property, presented by Clara Bakosi. So I will leave it to you, Clara, to take it from here. I will share your presentation right now. 1 second.
Thank you. Hello, everyone. Good evening. I hope you can all hear me well. Yes, so I'm a solicitor at Briffa, a law firm in London in the UK, and we specialise specifically on intellectual property and commercial contracts. So today I'm just going to be speaking to you briefly on how to protect your IP. If we just move to the next slide, that's just my name. And generally, intellectual property rights is an umbrella term. And under this umbrella term are a series of rights. And I've listed them out here and I will discuss them each in turn. So we have copyright, unregistered design rights, registered design rights, trademarks, patents, and then confidential information. So I'll discuss each of them in turn. So the next slide, we'll just be discussing copyright. So the important thing to note with copyright, and if we just go to the next slide again, copyright does not protect ideas and concepts alone. So if you come up with an idea or concept, it's not protected, nor does copyright subsist in a style of a technique or a process. So in essence, what copyright does protect, if we move to the next slide, it protects the expression of original ideas. So, and this can be grouped into 3 categories: literary works, which covers text, articles, books, lyrics, software codes; dramatic films, plays, TV programs, but TV programs must be recorded in order to attach some copyright; and artistic works such as graphic works, photographs, and sculptures. All of these things have copyright in it. We're just going to move to the next slide. So the good thing about copyright is that it is automatic. There is no need to register your copyright anywhere. It is just upon creation, you automatically have the right. And the ownership right belongs to the person who created it, so the author. And the only exception to this is if work has been created by an employee during the course of their employment. And in that case, then the employer will be the one that will own the copyright. And copyright then lasts for 70 years from the death of the creator. So as long as you live, you own the copyright. And then once you pass away, it will be 70 years from that time. So when we're looking at copyright infringement, if we just move to the next slide, how we assess whether there's been an infringement is whether the infringer has had access to your work. So ideally, you want to be in a position where your work was published or created first. And what we're then arguing is that because it was created first, this infringer has come along and copied your work, but they've copied it because they've had access to it. And then the second limb is, has the infringer copied a whole or substantial part of your work? So this test is more qualitative and than quantitative, and it's important to remember that it's not enough to show that the concept or idea of the work has been copied, because as you remember from the first slide, there is no copyright in ideas per se. It's the actual embodiment of the idea. So the story put down on paper is what you would have copyright protection in. And copyright in practice is proven by demonstrating that there are similarities between the two pieces of work that are more likely to have arisen as a result of copying than coincidence. And in instances where you can't necessarily prove that someone copied, what we would be relying on is the courts to draw an inference that copying has been made out, and they will do this if we can show that the similarities are striking between the two pieces of work, so that it's clear that this couldn't have been a coincidence. It's important to also note that the action of copyright is all about the acts of copying. So if someone can show that their work was created independently, and they can show that process of creation, and that they hadn't had access to your work and they hadn't copied it, then the inference of copying will be rebutted. So if we just move to the next slide then. So then this is just a case study, an example for you to see. So it's a question for you guys. When you look at these two pieces, the first bag was created by H&M, and that's the original. And then the alleged copy, the Forever 21 version, you can see that there are a slight differences between the two, but this would be a case of asking, has the whole or substantial part of the work been copied? And looking at these two pieces, we would say yes. The simple fact that the trees are slightly taller in the Forever 21 doesn't take away from the fact that the overall substantial part of the bag has been copied. They've changed the colors, they've changed the handles, but by and large, if you were to look at these two pieces together, you would see that there has been a copy, and that's really what the courts will be looking at, like, so what has been copied and is it substantial? So if we move to the next slide then, this is another example, and the question for you guys is, looking at these two pieces, has the whole or substantial part of the work been copied? As we can see here, the colouring is completely different. The sizes of the flowers are different. So this one probably wouldn't be as clear-shut case as the other one, because as you can see, the number of flowers are differ, the structure of the flowers differ, and then also the colours in themselves differ as well. So this one probably wouldn't be seen as a direct copy, and it would probably be difficult for the original designer to prove copying here because of those differences. And if the infringer could show that they had created this independently, again, that would get away from that claim of copyright. So moving to the next slide then. So how to prove your copyright? So the key here is keeping a record trail, a paper trail of your process, your creation process. So what we generally say is, don't save over work. Always save a new version of the work that you've created. Sign and date all your work. Use copyright notices. So as you can see on the screen, I have included a copyright notice, which is a C in a circle, Briffa 2021. A copyright notice doesn't mean that, you know, if you don't use it, you don't have copyright. If you remember, I said copyright is automatic. So regardless of whether you use a copyright notice or not, your work is still protected. What a copyright notice does is it puts everyone on notice that you are asserting your rights here. So this will get around the side where people will arguably say, oh, I thought that this was in the public domain and it was free to use. If it's clearly marked with a copyright notice, then it does mean that someone is clearly asserting their copyright. And then another way of acting as a deterrent to copying is also adding watermarks onto your work. With your branding or just any form of watermark. Generally, we find that people will not reproduce work that has a watermark over it. So that's a good way of dealing with that. But overall, the overarching thing that you must consider when you are working with freelancers or anyone that's not an employee, or when you're working for anybody and producing creative works for anybody, is to deal with ownership of rights in a contract. And if you are the one that wants to, you've hired someone to prepare or work with you, but to produce something, you want to ensure that you get the copyright assigned over to you from that person who's created that work, and vice versa. If you are the one that's providing the service, the creative service, and you want to be the one to own your copyright, you need to have that in writing, that nothing has been assigned by privy to the nature that, you know, both parties have entered into a particular agreement for X. So it's good to have everything documented, because that will keep you in good stead. So then moving to the next slide then, and we're looking at unregistered design rights. And similarly to copyright, unregistered design rights are automatic. They protect the shape and 3D configuration of an original design. So here we can see there's two pictures here, and the structure of that dress is what would be protected by unregistered design, and the shape and the configuration of the bodysuit is what is protected by that unregistered design. And then the important thing to note is that unregistered design rights do not protect methods or principles of construction. So if your design has a feature of how it, you know, how it's been constructed, or how it fits together, or there's a technical functionality to your design, that will not be protected by unregistered design rights. And also the important thing is unregistered design rights does not protect the common aspects of the shape or configuration. So for example, here we see this is just a normal standard table. If you were to register, if you were trying to claim some design right here, there wouldn't be any, because it's just a normal table. And then the unregistered design rights does not protect 2D features or surface patterns. So if we look at the armchair, then what would be protected by an unregistered design right is purely that shape of the armchair, the shape of the legs, but the pattern itself on the chair will not be protected. There are different rights that will protect that. So yes, as I said, unregistered design rights, there's no need for it to be registered. It is automatic. And similarly to copyright, it is owned by the creator. The only exception to this is if it is created by the employer. Sorry, if we just move to the next slide, please. And the next slide again. Yep, and the next slide. There we go. I'm so sorry. And then the protection for unregistered design rights in the UK is 10 to 15 years. It is different in the EU. And similarly with copyright, you must prove copying in order to bring an infringement claim for unregistered design. And it would be similarly the same test, has a substantial part of the design, unregistered design, been copied. And if we go to the next slide. So this is another case study here. So we have two pendants, necklace, and you can see the parrot infringing necklace on the left-hand side, and the Cartier parrot necklace on the right-hand side here. And the question here is, are the two substantially the same? And when we're looking at design rights, the test is similar to a copyright infringement test, but it is really, what is the overall impression that is created? Is it substantially the same? And arguably, you would say that although there are some minor differences between the two pendants, substantially they look the same. And if you were just glancing at them, you would probably mistake one for the other. The detail is not enough for it to, you know, for someone to argue that it's not substantially the same design. And then again, looking at these shoes, so the Jeffrey Campbell, if you just move to the next slide, the Jeffrey Campbell sandals, and the Jeffrey Campbell wedged fur shoe. You can see Forever 21. Forever 21 are key infringers here. They tend to do straight off the runway copies, and you can see that the structure of the designs are the same. So arguably, you know, here that there would be an infringement here, because you really can't tell any real difference. I mean, with the leopard print, maybe the leopard print is a bit more a bit more condensed in the Forever 21 version than the Jeffrey Campbell, but overall the shape and configuration of the two are the same. So then the key issue is how you created the work, and just ensuring that you retain ownership of this. So similarly to copyright, if you just move to the next slide, if you are hiring someone to produce or create things for you, you just need to show ownership. You need to keep a good record, proof of titles, and as I said, assignment documents or licenses that give you the rights to use the design. And you need to ensure that the design drawings are signed and dated, and also the deliberate watermarkings can prevent copying. So if we just move to the next slide, we're going to look at registered design rights. So registered design rights protect the 2D and 3D configuration, so the shape and the surface patterns, lines, contours, colors, textures, and materials of new designs that have individual character. So the test for a registered design is that the design must be new and novel, and that means that there mustn't be anything like it on the market that creates the same overall impression. So when someone looks at your new design, they shouldn't automatically think of something else. And as you can see here, we have examples of designs, registered designs. So the shoe here, it would be the entire shape, and also the pattern, the colouring, and the foot sole, the patterns at the bottom of that, and then the jacket, all of that is protected, along with the bags as well. All the ornamentations on the bags, the shape, will be protected by a registered design right. So it gives you a bit more, a broader scope, the registered design rights. So similarly, registered designs don't protect the method of or principles of construction. So how you've come to, you know, so for example, if we're looking at a woven piece, a design, the woven piece, or how that construction itself is not protectable. And then again, it does not protect the common aspects or shapes or configuration. So with this mug, so the only way that a mug like this would potentially be registerable is if it had some sort of graphic pattern on it, but the mug itself would not be what you would be calling, you would not be saying you have protection. It would be the pattern itself, unless the mug was stylized in a funky way and the handle was designed in a funky way. If you just move to the next slide, please. Yes, there we go. So as I said, the methods and principles of construction are not protected, and common aspects of the shape are not protected also. So looking there at that mug, just the shape of that mug in itself is not protectable. But what would be protectable is if the handle was designed in a funky way, or the base was slightly different, then maybe that would be protectable by a registered design. So for a registered design, you need it needs to be registered. So in order to get registration, you need to file an application and get the registration. You'll get a certificate. It is renewable every 5 years, and then you'll have it for a maximum of 5 years, 25 years. Registered design rights are territorial. So if you register your design in the UK, it won't necessarily protect you anywhere else in the world. You would need to file registered designs in those territories as well. There is a grace period for registering designs. So although your design must be new and novel and have individual character and must not create a déjà vu effect, the moment you publish your design online or anywhere, disclose it to the public, then you must, if you want registered design protection, you will need to register your design within 12 months of making it public. So for example, if I design something today, posted it on Instagram, I would have 12 months from today's date to make my application. And if I do it within that time frame, I will be fine and my registration will be accepted. So for an infringement, if we just move to the next slide, the question of whether there is an infringement is whether the same overall impression is created to the registered design. So if somebody created something and what we're saying is the overall impression created by both designs are the same, that would be the test for infringement. The difference with unregistered design rights and copyright is you need to prove copying. However, the benefit of having a registered design right is that you don't need to prove copying. It doesn't matter if it was independently created either, it will still infringe if it creates the same overall impression and it's identical looking. So that's the benefit of having a registered design. It gets over that hurdle of copying. So then looking at these two, move to the next slide, these two designs here, sorry, just go back a bit. Yep, there we go, thank you. So these two designs here, we can see that there are some slight differences between the two designs. So the Forever 21 design copy, we can see, but overall, what has been copied and what would arguably be the dominating feature is the striped and the rose detail here. And that's just been copied. There's additional things in the Anna Sue design that is different, but overall we would be arguing that these create the same overall impression. I mean, if you blink, you wouldn't really notice the differences too much. So this would be a clear case of registered design infringement. So then moving to the next slide, which is trademarks then, and moving on again. Trademarks are essentially a badge of origin. It is your brand identifier, and there are various things that we would suggest are brand identifiers. So the words of your brand, the logo, the stylized words, shapes, color, music, all of these things can be brand identifiers. So if you have these things within your brand, and anything that you have in your brand that you think consumers, your clients will see, and they automatically know that it is your brand, it's your branding, these are the things that we should try and protect with trademarks. And as stated below, words, slogans, logos, stylized words, shapes, colors, music, can all be registered as trademarks. So if we just move to the next slide. So when we talk about words, we're talking about the plain words. And so as you can see, Dolce and Gabbana, just the plain words, this is registrable and this will be a registered design, a registered trademark. So if we registered this as a trademark, what the broad words do is it gives you protection for those words in any form that they appear. So that's irrespective of the size, the color, the stylization, however way that it appears, you will be protected for those words in relation to particular goods and services. And then slogans, impossible is nothing. So there are particular rules with slogans. Some slogans may not be registrable, but by and large, there are particular slogans or taglines that you can register and they can function as a trademark. So if we think of impossible is nothing is here, but if we think of something that is very popular, Nike, just do it. Is a slogan that is used, and KFC, finger licking good, is another slogan as well. And if we move to the next slide, and then logos here, you can see that these are examples of what we mean by logos. So it could just be plain words like Hugo Boss, or it could be something graphical like the low cost crocodile, or Ralph Lauren there, or the Nike tick. So if we just move to the next slide. So one of the two rules for registering a trademark is that it must be distinctive and must not be descriptive. So the example here is the restaurant the brand name is called Restaurant, and arguably this would be refused by the UK registry because it is descriptive of the goods and services. And when we say goods and services, if we move to the next slide, it's just really a category of 45 goods and services, categories of goods and services that you can register your brand under. So here is a list of 45, and as you can see, if we look somewhere in the middle there, I think, or the end, sorry, number 25 is clothing, and clothing covers footwear, headwear, and then if you look above, there's furniture for class 20. So essentially what we would be doing is we would be advising our clients on what we would consider their key core classes that they should register their mark in. So for example, if we were looking at a retail company, so H&M, we would arguably be saying they should focus on class 25 for clothing, class 14 for bags, for jewelry, class 18 for bags, and then for services, class 35 for retail and wholesale services. So that's how the class system works. And your protection will give you a monopoly right to use a particular brand name in relation to specific goods and services. And what that does is it gives you a monopoly right to stop anyone from using something similar or identical to you in relation to those goods and services. So trademarks registration, again, is required. In order to have a registered trademark, you have to file an application. If you're successful, you will have the protection for 10 years, and it can be renewed for 10 years continuously. If you just move to the next slide. Similarly with registered designs, it is protected in the UK, and it won't protect you anywhere else. So for trademarks, you need to file trademarks in each territory that you use your brand, and you only have protection for your listed goods and services. And when we're looking at infringement of a trademark, we are really looking at whether the marks themselves are similar or identical, and whether the goods and services offered by both marks are similar and identical. And is there the likelihood that consumers will be confused? And if there is, then you're in a good position to kind of stop someone from using a brand name that is similar to yours. And the reason why we say it's good to protect your trademark is because trademarks are property rights which can be bought, sold and licensed. and they really do house the assets of your business. So they have the goodwill in it. So people identify your brand by your branding, your brand name, your trademarks, and that's where really the money in the business is. It's in that goodwill that your consumers, your clients can attach to your brand. And the risk, therefore, of not registering your trademark is most countries are first to file nations, which means if you delay filing your trademark application, there is a risk in some territories that somebody could get in there before you. And if they get in there before you and register something similar, identical to yours, they potentially could have good grounds to get you to stop using your mark. If you'd been using your mark for a number of years, as an unregistered trademark, there are some limited common law rights that you do have to challenge someone's registration, but the threshold for that, which is a passing off claim, is quite high. So the best position to be in is to be one where you you have your registered trademark registered. So then looking at the case study, should we just move to the next slide? Here we have the House of Fraser pigeon logo and the Jack Willis trademark. So there we can see them there, and we can see that although they're not identical, there are some similarities. And with this one, if we just move to the next slide, Jack Willis sued House of Fraser for trademark infringement and passing off for the pigeon logo, and the High Court concluded that Jack Willis's logo had been infringed by House of Fraser. And as I said, if we just flick back, the test is it confusingly similar? So it doesn't have to look identical, and that's the strength of the trademark. It doesn't have to look identical. It just needs to look confusingly similar and be used in relation to the same goods or services. In this case, it was used on clothing, which is the same. And is there the likelihood that consumers will be confused? And the judge there decided that. So if we just move to the next slide. So then very quickly, patents. Patents protect inventions. And in essence, it's really processes or solutions that processes that find a better way of doing something or a solution to a problem. For a patent to be registrable, it must be new and novel, and that means there mustn't be anything like it anywhere in the world. And if it's building on something that's already there, it must involve an inventive step. An inventive step just purely means that it mustn't be obvious to someone in that particular field, and it must be capable of industrial application. So if you are lucky enough to be granted a patent, you will get a monopoly right for 20 years. And after that 20 years is up, then your patent protection falls away, and it's open to everybody to be able to reverse engineer and create something and use the patent information that you've put out there to develop and build on something more. There are particular things that are excluded from patent protection, so scientific theory, mathematical methods, and then also software. Pure software is excluded. So when we're thinking of processes, I'm not sure if you are familiar with Viennetta, that ice cream, but the process in creating that ice cream had a patent. The key thing with patent protection is that in order for you to have a successful application, you must not disclose your patent, your invention, to anyone. And if you do make any disclosures, it must be made under the form of a non-disclosure agreement. And a good example of a product that has patent protection is Dyson. For many of their inventions and their designs have patent protection. So moving then on to the next slide, which is confidential information. And confidential information protects or covers trade secrets, know-how, and non-public information. So things that are crucial to your business that if it potentially fell in the wrong hands could harm your business or be detrimental would be covered by confidential information. Confidential information, really it's just information, and the only way that you can protect that is by a contract. just mere discussions. If you have mere discussions and you've basically said, oh, this is confidential, don't say anything to anybody, that might be good. But if someone did go off and break that verbal contract, you probably do have an action that you could bring, but it's quite difficult. The best position to be in is to be in one where you have a contract in place and it's clearly set out what the confidential information is and what the parties are allowed to do with the confidential information. The key thing with a contract is if someone signs something which says, you can't do X, they're more it will act as a deterrent. So people don't necessarily set out to break contracts. They do know the importance of contracts, and if you have an NDA signed, generally people will try and respect that. So that is the key thing with confidential information. And then a good example of confidential information, if we move to the next slide, is Coca-Cola. So their recipe was originally not written down. Just a few people in the business knew what the recipe is. However, they needed a loan, and then they wrote it down on a piece of paper and used that as collateral. And now that piece of paper is now kept under a safe lock and key. And if we think back to the KFC recipe, that is another thing that is confidential information. But confidential information could also extend to kind of business records sometimes and client information and stuff like that. So if you are having employees or freelancers and they are interacting with things that you believe are crucial confidential information, you should have something in their agreements which says they cannot just go off and use that confidential information at the termination of their engagement. But the important thing to note with confidential information is if someone guesses the information independently and it wasn't as a result of a breach of the contract that you had with them, then you probably won't have an action for a breach of contract if you cannot prove that the breach resulted, the information was exposed as a result of one party's breach. So that is just the important thing to note there. So how to commercialize your IP, so the important thing, if we just move to the next slide, is identifying what rights you do have. So I've just gone through a whole load of different types of rights that you have. You might have unregistered trademark rights, you might have copyright, and it's about identifying what rights do you have, who owns these rights, and what stage are you at. So if you're at the stage where you have unregistered trademark rights, you identify unregistered trademarks, and you're at the stage where you potentially could be looking at registering your trademark. And then how do you see the future, and just looking at how and where the business is going and seeing how we can protect those rights going forward. If we just move to the next slide. So how can you make money from your IP, your registered IP, your intellectual property rights? So as I alluded to before, you can assign rights. So you can assign trademarks, you can assign copyright, you can assign patents and design rights. And assignments are essentially selling the intellectual property rights to a third party, and it's giving them complete ownership over that IP. The other way that you can, and you can do that for a fee. Sometimes you do assignments for a huge amount, or it could be a nominal amount. And then the other way is licensing. Licensing is, in essence, you retain ownership, but you are just allowing somebody to either use your copyright materials or your trademarks in a franchising arrangement, and they're purely using it for a particular period, and they will pay you for that licensing period. And then other ways is thinking about when you're manufacturing, distributing, or even agency agreements, how can IP be exploited, and how can you ensure in your agreements that the IP that is exploited is still retained by you. And a key way of doing this is by ensuring that these agreements clearly have intellectual property clauses, and then joint venture agreements where both parties collaboratively work together to create IP and it's jointly held together is a good way of making money from your IP, which you will then license on to somebody else as well. So then just moving on to the next slide. So when you're thinking of licensing, the key thing is, do you have the right to grant the license? Are you the owner? Really, only the owner should be able to grant a license. There are some limited instances where a sub-license can be granted. And who is the licensee? So if it's a manufacturing arrangement or a distributor or an agent, who are these people that you're licensing to? And will it be a sole exclusive or non-exclusive license? So you can set the parameters of how you wish the license to function. So it could be a sole license or exclusive license. And what intellectual property rights are being licensed is the key here. So is it an unregistered right? Is it a registered right? And this must all be clearly defined in your licensing agreement. And where also will the licenses be, where will the intellectual property rights be licensed? So for example, I could grant a license for use in India or in the US and in the or in the UK only. So you can set, as I said, the parameters of when of how the license functions and when will the license end. Will it be a fixed term or will it be perpetual? Some situations will cause for perpetual license if there's been a collaborative effort, or sometimes you will want it to be fixed by to a certain period. So then moving on to the next slide then. So yes, so it must be clear at the time of signing what the intention of the license is. It must be clear from the time of signing what the fee and royalty structure is and the basis and calculations of the fixed or percentage or how it will be calculated. And then also other information that may be required, e.g. advertising or sales records to show evidence of use. So if we move to the next slide. So just a summary then as we come to the end. So the key thing that I suggest that you take away from here is that it is important for you to identify your IP rights. What intellectual property rights does your business hold, and how best can you protect your IP rights? Is it by registration or is it by a contract? In some instances, it might be both of those or it will be one or the other. And then exploiting your IP, how does your business make its money and how will it make its money for its IP, and making that decision earlier on. And if we just move to the next slide then. And then enforcing your IP, and that's purely dealing with infringement. So at all stages, we should be looking at how best to enforce our IP. If we notice that there's an infringer, get speaking to a solicitor, a lawyer, to understand what your options are in that instance and how to take action. Next slide, please. So yeah, I've come to the end of the slide. So this is the information for my my firm, the firm that I work with. And if you do have any further questions or have any agreements that you would like someone to have a look at, or you would like to discuss registering any of your rights, do get in contact with me on the email address there, or you could give us a telephone call as well. We do offer free 30-minute consultations as well. So if I know that you're not based in the UK, but if you have plans for doing work in the UK and you want to talk around, you know, what your considerations for IP is, do get in contact. I hope you found the session useful, and I will stay on for, I think there will be a question and answer session just shortly.
Thank you so much, Clara, for the wonderful and detailed presentation. And now we're going to open the floor for the Q&A. Guys, please type in your questions. Let me keep this on. Clara, if you can take a look at the Q&A box You will find
Okay.
it below.
Yes.
Okay. So guys, what you've written in just comments, please write your questions in the Q&A. I'm just gonna Some attendees are raising their hands, but unfortunately we cannot take your questions. We need you to type it in, please. Noha or Rehab, are you guys here? Can you hear me? Yes, I just need you to translate in English.
Yes, please.
Yes, the questions written in Arabic.
Should we go to the next question in the meantime then?
Yes, we can hear you. Can you hear us? Okay,
Hello?
Clara, please click.
I can't hear you.
Okay. Okay, Clara, can you see the globe icon at the end? Please choose the English.
Okay.
Mm.
Okay. Okay. I can hear you. Yes. I will answer that briefly. So because I'm a UK lawyer, so I can't advise specifically on Egyptian law, unfortunately. But if you do send me so if you just email me your query, what I can do is I can speak to, we do have firms of solicitors that we work with, or firms of lawyers in other territories, and I can feed that question on to them to see how best to advise you on that. But generally speaking, contracts are free drafted. So in the UK specifically, and in other territories that like the EU, you basically draft the clause as you want it. So there might not be anything already drafted, but you do have the freedom to draft the terms of how you want your IP to be used in the UK, and that's what I mean when I say in agreements, draft something that kind of fits your needs. So, for example, if you wanted to retain all the IP that you generate, we would draft a bespoke clause which deals with that. So I hope that answers that question. And then I guess the next question is in English, so I can read that. So, what to do if I started a practice and found that there is a firm with the same name? So I would say that's not a great position to be in. So there's two things. So once you find that there's somebody else with a similar name to yours, the crucial thing is to check whether they've registered a trademark for that name. So someone could be using a company name, and that necessarily isn't a trademark registration. You would need to, as I said, apply for a trademark. Just using a name is not a registered trademark. And then also another thing is to try and see if you can identify how long they've been using that trademark for. There's two tactics. You could just decide, this is not great for me. Potentially this person has been using it before me, so they potentially could have a passing off claim against me if we're both using the name in relation to the same goods and services. Secondly, you might take a more risk adverse approach, which would be to still go ahead with registering your trademark, get in there before them, and then write to them sometime after. And this is what some clients do, and tell that person to stop using that trademark. The risk there is that if they have been using their brand name for a substantial period of time before you, they have the earlier right, and they arguably could bring a passing off claim against you. But my advice would be pick another name, because that would just be the safest thing to do. Because you just don't want a claim against you, and you don't want that risk hanging over your head. The next question is in Arabic, and I've tried to turn on the translation. Yes, I can hear you. Yeah. So yeah, shapes. You can protect a trademark for a face if that is your brand. That is fine. And the protection is the same. So whether it's a logo or a word mark in the UK, the protection is still 10 years. It doesn't matter what it is. The protection is 10 years. So yes, you could protect graphical logos, so graphical elements. So if it's a face, a hand, you can protect that. That is fine. Yeah, okay. The next one, is it possible to register a face as a trademark? Okay, yeah, I think that's the same question in English again. We are selling handmade furniture. However, some of our suppliers has unique items that they're afraid of selling online to avoid designs being copied. How can we mitigate against this issue? So, yeah, so what you could do is keep a close eye. So essentially, if we find that somebody, the thing is, if someone is going to copy your work, they're just going to copy your work. And what we would advise is each time you identify someone that has copied your design, we would advise sending a cease and desist letter. The other way of mitigating against that risk is on your website, having clear notices on your website saying that the material, the pictures, the designs are all protected by copyright, and nobody is allowed to download or reproduce these without your consent. You could also add watermarks to these images online. But as I said, if someone is going to copy your design, they will just copy your design. And then what we need to be doing is looking at what's the next stage of dealing with that infringement. And the next stage would be sending a cease and desist letter to them. And it's about being robust at that. So if someone knows that each time they copy, there's potentially an action that will be filed against them, they might be reluctant to do so. So it's really about enforcing your rights that you have as well. And if possible, register some of those designs. The next question is in Arabic. Could I have a translation, please?
No. No.
Sorry, there's two people talking at the same time. I can't hear, sorry.
Both of you guys are talking right now. Please, just one. Yes, can hear you. Any question in Arabic?
Mohsen.
The board
No.
games? No, not yet.
Yes, so with a board game that would fall within a design registration. So yes, that's where you would register the design, the board game. So what it looks like, the shape, the coloring, all of that will be registered as a registered design. In terms of when to register your design, I would and what you are registering. So you can register line drawings, you can register the finished article, so images of the finished product. But the important thing to note with registered designs is your registered design protects you for what is registered. So if we register line drawings, then that gives us a broader kind of scope. So for example, if we change the pattern and the coloring of the design, it's not restricted to colors. If you just took a picture of the board game as the finished prototype, and that's what you registered, what you'll be protected for is the prototype as pictured. So all the lines, the contours, the coloring, and all of those things. We would say that ideally, with a registered design, the grace period is the ticking time bomb. So the moment that that product has been published online somewhere or disclosed somewhere, you have 12 months in which you need to register that design. So anywhere between that 12-month period, you can register the design. You can register the design at the beginning stages before you've even finalized the prototype, if you wanted to. But obviously there are greater considerations that you need to think about. So if you're consistently developing the design of the board game, then you wouldn't want to register the earliest version of that, because whatever you come to at the end will be invalidated by the early registration. So if you remember what I said, for design registration, it has to be new and novel and it must not create the same overall impression, unless what we're saying is the first design that we've registered and what we've come to at the end as the final product look completely different, then both things are registrable. But what you want to be protecting is the design as it will function. So ideally, you should be waiting till you finalize what the design is going to look like and then register that. I don't know if that's clear.
We just got so many questions right now, and we ran out of time.
Yes,
so
we have.
I don't want to take more of your time, so you think it's okay if we talk couple more questions?
Yes, I can take just a couple more. Yeah, that's fine. Yeah.
Thank you so much. We really appreciate it. You can choose any 2 English questions to save a little bit of time.
Okay. All right. So how do I protect my ideas through proposal stage with the client while the contract is not signed? Don't disclose the ideas is the key there. If you disclose anything before you have a contract and you haven't stipulated that it is confidential, then that disclosure makes it not confidential, if that makes sense. So basically what we're saying with an agreement, a confidentiality agreement, is we're saying that the information that we hold is confidential and hasn't been disclosed anywhere. It's not in the public domain. If you disclose anything before the contract is signed, it kind of negates what we're saying is confidential, because it's already been disclosed, if that makes sense. So ideally, don't disclose it unless the contract is signed. Don't disclose your ideas. Don't talk about them is the advice that I'd give to that. And then once the contract is signed, then feel comfortable to disclose. Is it possible to register a face as a trademark like the Kentucky brand? Yes, that's possible. As I said before, you just file a trademark. You would have to register it in relation to specific goods and services. The process is filling an application, doing the specifications, so picking the correct classes, and then completing the fee. But if whoever asked this question, just drop me an email and I can give you some quotes for how much that would cost in the UK, and we can discuss that further. But yes, it is possible to register a face as a trademark. Is it possible to register an old industrial design, such as an old Mini Rover car of the 49th model, for example? The parent company no longer produces this model. So in the UK, so the threshold for registry. So okay, the answer is yes, it is possible to file an application to register an old industrial design. But if we're looking at why you would register a design, you want to register a design so you can prevent other people from reproducing the same thing that you create. So because this is already, the 49th model is already in the public domain, whilst the examination process for a registered design application will not flag this up potentially, and you probably will get your design registration, when you are trying to enforce that registration against somebody else that is creating the same 49th model, they will say to you, your design registration is invalid because this is something that was already in the public domain. If what you were doing was adapting the 49th model, and there were some new adaptations that were made to the design, what would be protected is the adaptations. So everything that is new about the design that you've adapted will be protected, but any aspect of it that remains the same as the 49th model will not be protectable. The other thing to note about that, though, is that there will still be copyright in the 49th model. So registering that model may, if the owner became aware of that, they might have an issue with that. So it's really about looking at all the different IP rights. So whilst the registered design for the Mini Rover car may not still be intact, there might be other unregistered rights that are still in place that prevent you from doing what you want to do. But it would be good if that person who sent that question could send me an email, and we could potentially look at that in a bit more detail as well. Very, very interesting question. And then the last one that's in English, not the last one, oh gosh, sorry. I have worked as an advertising model. I have some followers and I have a startup company in the field of handicrafts. Is it better to work on personal marketing for myself as a model or as a public figure, so that my brand as a model is the same as my company, or is it better to create separate brands? So that is a personal choice. I mean, that's not really a legal question. It's more of a commercial question. So what really makes sense for you? There's particular reasons why people divide their brand, so they'll have something that, you know, is separate to their personal identity, or they could house everything together. So one thing to consider, though, is that if we're looking at, so if everything is tied to your name and you then sell your IP, you don't have the rights to your name in relation to those particular things that you've sold on. So you would, and that's just something to be to consider. And if there's any brand or reputational issues, it may be tied to your name as well. So those are more commercial things than a legal question. But as I said, I'm happy to discuss that in a bit more detail, because there's a lot to consider with that, and I can't just give an easy answer just in a couple of moments, if that helps. So I want to ask if there is a slight difference in design, just like the tiger shoe you presented, or the tall tree on the bag. So this makes them different to a trademark. So a trademark is a badge of origin. So that's the important thing to note. A trademark is a badge of origin. So if we think of Starbucks, that logo is on cups, it's on packaging, and it's just a brand identifier. And arguably, somebody cannot use that same logo in relation to food, coffee, and some other things that Starbucks have registered that logo specifically for. Whereas a design registration is different, because the design is so basically, if we were just looking at that the two bags, so the beach, I can't remember what the words was, but that beach bag, so you could have just registered that design as in the bag, but what you're claiming your registration in is just the trees, the structure of the trees and that wording. And that means that if someone copied that design and put it on a cup or put it on a t-shirt, that would be infringing. It doesn't matter where it appears, if that makes sense. So that's the difference. Whereas a trademark, your protection is limited to the goods and service which you've registered your mark for. A design registration protects just the design itself. It doesn't matter where it appears or how it's used. If you reproduce that, that's an infringement. I am running out of time, guys, and I'm really...
No problem at all. Thank you so much for going over the allocated time, like 15 minutes over. So we really appreciate it, and appreciate that you really cared about answering everyone's questions that came in. So yeah. Thanks so much, Clara. We really appreciate all the effort and the great presentation today. And hopefully we will see you again in the future.
Absolutely. What I would say, if there's anyone that I didn't get around to answer your question, or you don't think I answered it, please do drop me an email and I'll get round to answering your question. And I hope that you found today's session useful. Thank you very much for having me.
Thank you, Clara. It was such a pleasure.
Okay.
See you.
All right, take care. Bye-bye.
Bye. جماعة الباقي خليكم معايا شوية. أنا بس كان في حد هو بس مش عارفة في حاجة في تمام أوكي. بس يا جماعة كان في حد قال إن مفيش قانون لحماية الملكية الفكرية في مصر، بس فيه اللي هو في قانون رقم 82 في سنة 2002، فهو موجود. والفيديو الانفوجرافيك اللي أنا عرضته في الأول ده كان بيوضح إيه الجهات الحكومية اللي تبعها. يعني مثلا خلينا نقول براءات الاختراع تبع أكاديمية البحث العلمي، ففي مصر منظمات او خلينا نقول هيئات مخصصه على حسب نوع الملكيه الفكريه بتاعتك. فانا بس حابه اعرض الفيديو مره تاني، وبليز ركزوا في انا عموما هبعت لكم اللينك، بس انا حابه اعرضه تاني عشان بس المعلومه تثبت اني لا موجود قانون حمايه الملكيه الفكريه، وفي اماكن بتسجل يعني زي ما حكيت على حسب نوع الملكيه الفكريه ليها الهيئه او المنظمه الحكوميه الخاصه بيها. فاسمحوا لي بس اشير معاكم السكرين.
بتعرف الملكية الفكرية بأنها إبداعات العقل من اختراعات ومصنفات أدبية وفنية بيتم استخدامها في التجارة، وده وفقاً للمنظمة العالمية للملكية الفكرية ويبو. الملكية الفكرية ليها أنواع مختلفة محمية قانونياً بحقوق وعقوبات ومدة زمنية معينة لكل نوع، زي العلامات التجارية وبراءات الاختراع وحقوق النشر والتصاميم الصناعية والمؤشرات الجغرافية والأسرار التجارية. مصر تعتبر من أوائل الدول اللي اهتمت بحماية حقوق الملكية الفكرية وانضمت للعديد من المعاهدات الدولية. وفقاً لتقرير التنافسية العالمية لسنة 2019 الصادر عن المنتدى الاقتصادي العالمي، مصر احتلت المركز 89 من 141 بالنسبة لمؤشر حماية حقوق الملكية الفكرية، مقارنة بالمركز 124 لسنة 2018. الغلطات اللي كتير من رواد الأعمال بيقعوا فيها هي قلة الاهتمام بتسجيل الملكية الفكرية لشركتهم الناشئة، وده بيرجع لقلة الوعي بأهمية حقوق الملكية الفكرية والوقت والفلوس اللي بيضيعوا في عملية التسجيل، وتعدد الجهات الحكومية اللي بتقوم بتسجيل الملكية الفكرية زي أكاديمية البحث العلمي، جهاز تنمية التجارة الداخلية، المجلس الأعلى للثقافة، هيئة تنمية صناعة تكنولوجيا المعلومات. تسجيل الملكية الفكرية مش بس بيحمي رواد الأعمال من إن أفكارهم تتسرق، وكمان بيديهم ثقة ومصداقية أكبر لما يتعاملوا مع مستثمرين أو شركاء محتملين.
بس كده يا جماعة، يعني أتمنى الفيديو يكون برضو ثبت المعلومات أكتر. لو حد محتاجه بس يبلغنا على الواتساب جروب وأنا هبعت لكم اللينك. أتمنى تكونوا استفدتوا النهاردة من السيشن. وموضوع الترانسليشن ده بيبقى رخم أول مرة، بس إحنا لسه عندنا تقريبا ثلاث سيشنز تانية هيجي لنا فيها يوكي سبيكر، فإحنا مع بعض إن شاء الله هنفهمكم إزاي بيتعمل، وإن شاء الله المرات الجاية تكون أفضل بكتير. بس كده، واشوفكم يوم الاحد الجاي بقى ان شاء الله. باي باي.